So this should be a session of what time? 1 hour? You said this is short.
Today, 1 hour should be sufficient. That is my estimate. Because the subject itself is only minority guardianship. The minor subject, so therefore it should be sufficient time. Because I am not dealing with Guardian and WhatsApp. We'll have a separate session for that.
Yes. Good evening, friends. Though we had earlier committed to go ahead with the session of Hindu Minority and Guardianship Act 1956. And whence there is Mr. S.R. Somashekhar, former Principal District Judge, Bangalore Rural District. One thing, as we always say, is quite sure that it would be lucid and self-explanatory. And as and when we request, sir has always been kind enough to accept it. And more so, we always request him to take some niche areas. Thank you, sir, for accepting our invite. Over to you.
Right. Good evening, Mr. Vikas Chetrat, and good evening all the participants. Thank you, Vikas Chetrat, for one more opportunity. I had earlier suggested that I should take up section 29 of the Guardian and WhatsApp Act also, along with this. Later, I thought that I can exclude it and we can have a separate session on the entire Guardian and WhatsApp Act sometime later. Now, this Hindu Minority and Guardianship Act, it came into force on 25/8/1956. A part of the Hindu code where 4 laws were codified. The law relating to marriage, the Hindu Marriage Act, that was the first law. Then the Hindu Succession Act, law related to succession. It Minority and Guardianship Act, which came into force on 25/8/1956. The last one is the Hindu Adoptions and Maintenance Act. Mullah in his commentary says, adoptions and maintenance are two different topics. Only to avoid one more legislation, probably the parliament thought of clubbing the two subjects into one. Otherwise, there is no justification for adoption.
So you will have to unmute yourself. So you will have to unmute.
Now you are able to hear me.
So your video, oh, one audio is off. So you are speaking from some other? Yeah, now it's fine. So what can be done is, since there's a break, we can start afresh. Hello.
Huh?
So we can start afresh since there will be a break in the video. Hello. Hello. Hello.
Yes.
So I said we can start afresh since there is a break and we have just started it off. Good evening, friends. Today's session will be by Mr. S.R. Somashekhar, a former Principal District Judge, Bangalore District, Rural District, and he will be taking us across the wide spectrum of knowledge in respect of Hindu Minority and Guardianship Act 1956. Over to you, sir.
An act to amend and codify certain parts of the law related to minority and guardianship among Hindus. What does this indicate? The entire law relating to minority and guardianship is not contained in the Hindu Minority and Guardianship Act. We have the Guardian and Wards Act, a pre-constitution legislation that still governs us. So only certain parts of the law relating to minority and guardianship amongst Hindus is covered by this enactment of 1956. Let there be no confusion in this regard. We have Order 32 CPC, which speaks of suits by or against minors. If it is a minor who institutes a suit, then the person who institutes the suit on the minor's behalf is referred to as next friend, while the person who represents the defendant minor is referred to as guardian. That has nothing to do with this. Now, the Guardian and Wards Act, if I may roughly put it, is a procedural enactment. Of course, there may be a few provisions in it also, which have an indication of substantive law, but by and large, it is a procedural enactment. Who can be appointed as a guardian, who can be declared as a guardian, custody and other matters are dealt in great detail in the Guardian and Wards Act. Therefore, I have chosen not to speak about it today. I will have some other occasion to speak on that. This Hindu Minority and Guardianship Act is a substantive law. Then, Section 2 is important. The provisions of this Act shall be in addition to and not save as hereinafter expressly provided in derogation of the Guardians and Wards Act 1890. That's why I said we'll have to read both the enactments. Guardian and Wards Act is still in force. This Act, the Hindu Minority and Guardianship Act, is something supplemental to it. It is not in derogation of it. We'll have to read both the enactments, but not today, on some other occasion. Then application of the Act, Section 3. We have a similar section in the other three enactments also, the Hindu Marriage Act, the Hindu Succession Act, Hindu Adoptions and Maintenance Act. Obviously, it refers to Hindus. Hindus include Veerashaivas, Lingayats, then persons belonging to Brahma, Prarthana and Arya Samaj, Buddhist, Jains, Sikhs religion. So they are all included as far as the definition is concerned. Now, straight away, let us go to Section 4, which is important for us. Or before that, let me refer to Section 5. Overriding effect of the Act. Save as otherwise expressly provided in this Act, any text, rule or interpretation of Hindu law, that is the classic Hindu law, or any custom or usage as part of that law in force, immediately before the commencement of this Act, shall cease to have effect with respect to any matter for which provision is made in this Act. You find a similar provision in the other three enactments also. So any usage, custom, or any rule or interpretation of the classic Hindu law, if it is inconsistent with this Act, it is the Act which prevails. Any other law in force immediately before the commencement of this Act shall cease to have effect insofar as it is inconsistent with any of the provisions contained in the Act. Just as any text, rule, interpretation, custom, or usage, if it is inconsistent with this Act, it is the Act that prevails. Similarly, if there is any other law in force immediately before 25/8/1956 related to minority and guardianship, and that is inconsistent with this enactment, it is this enactment which prevails. Then let us go to Section 4. Definitions. Minor means a person who has not completed the age of 18 years. Everybody knows it, does not call for much discussion. 4B, guardian. Please give a careful reading to this. Means a person having the care of the person of a minor or of his property, or both his person and property. So guardian is not only for the person of the minor, but also in respect of his property, and includes a natural guardian. A guardian appointed by the will of the minor's father or mother, popularly called as testamentary guardian. The father or mother leaves behind a will saying that in the event of our death, so and so shall be the guardian of our minor child. That person would be the guardian of that child, and that guardian is called a testamentary guardian. Who are those persons who can appoint a guardian by their will? Only the parents. Guardian appointed or declared by a court. This appointment or declaration is not under the Hindu Minority and Guardianship Act, but it is under the Guardian and Wards Act. We should be very clear about it. So, appointment and declaration of a person as a guardian is done under the Guardian and Wards Act. A detailed procedure is contemplated therein. A person empowered to act as such by or under any enactment related to any court of wards. Of course, earlier there were these court of wards. If they had empowered a person to act as a guardian, he would also be a guardian. See, natural guardian means any of the guardians mentioned in section 6. So, B says, 4B says, natural guardian is also a guardian. Who that natural guardian is? That is covered by section 6. Please read it very carefully. The natural guardians of a Hindu minor, in respect of the minor's person, as well as in respect of the minor's property, both in respect of the minor's person and in respect of the minor's property, what is stated in the bracket should not be excluded. That is more important. Excluding his or her undivided interest in joint family property. I need to spend some time on this a little later. Right now, not. Excluding his or her undivided interest in joint family property. This takes us to classic Hindu law regarding the concept of joint family property, the powers of a manager, karta and all that. We'll take it up a little later. So now the natural guardian is the person who is defined here. Who are those persons? In the case of a boy or an unmarried girl, the father. So the natural guardian is father. Let there be no misconception that it is mother. It is father. And after him, what's the meaning given to that word after by the Supreme Court? We'll see later. And after him, the mother. So what's the order? Father, and after the father, mother, provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother. This is quite understandable. At younger child, the custody should be with the mother. So let there be no confusion. Who is a natural guardian? Father is the natural guardian. After him, the mother. Custody will ordinarily be with the mother, provided the minor child is below the age of 5 years, 5 or below. In the case of an illegitimate boy or an illegitimate unmarried girl, the mother, and after her, the father. Obviously, in the case of an illegitimate child, it is the mother who should be the natural guardian, and after her, the father. In the case of a married girl, the husband. Here, we'll have to be a little careful. The Hindu Marriage Act 1955 prohibits bigamy amongst Hindus. Number 1. Number 2, there is an age restriction also. In the case of a boy, not below 21 years. In the case of a girl, not below 18 years. Now, if we just read this provision as it is, in the case of a married girl, the husband, it might give an impression to some who have not read the Hindu Marriage Act or who get confused that there could be the marriage of a minor girl also. No. See, what we will have to keep in view is the Hindu Minority and Guardianship Act came into force on 25/8/1956, while the Hindu Marriage Act came into force a year earlier on 18/5/1955. In fact, even after the Hindu Marriage Act came into force on 18/5/1955 till 1976, when the Marriage Laws Amendment Act was introduced, the position was the bride should have completed the age of 15 years and the bridegroom 18 years. So it is in this context we'll have to read it. So it does not mean that even subsequent to the Marriage Laws Amendment Act of 1976, a girl below the age of 18 years could be given in marriage. That cannot be the interpretation placed on this. Then, provided that no person shall be entitled to act as the natural guardian of a minor under the provisions of this section, if he has ceased to be a Hindu, or if he has completely and finally renounced the world, becoming a hermit, vanaprastha, or ascetic, yati, or sannyasi. In this section, the expressions father and mother do not include a stepfather and a stepmother. You will have to be careful in respect of all these substantive laws. Let us not presume anything. When a doubt occurs to our mind, let us consult the statute. If the statute does not give us any indication, let us read decisions of the Supreme Court and the High Court, whose decision binds the people of that particular state. Let us not presume anything. 7. Natural guardianship of an adopted son. The natural guardianship of an adopted son who is a minor passes on adoption to the adoptive father and after him to the adoptive mother. So in effect, what section 6 and 7 connote is the natural guardian is the father or the adoptive father as the case may be, and after him the mother. In the case of an illegitimate boy or an illegitimate girl, the mother and after her father, custody ordinarily shall remain with the mother. Now, what is this after? The dictionary meaning or what we have understood so far would give us an indication that it is only after the death of the father, the mother would be the natural guardian. That's the interpretation one can place. Why? It is the literal interpretation one can place. But whatever be the dictionary meaning, whatever be the meaning that we assign by our knowledge of English, cannot be the interpretation in law. We have a decision of a three-judge bench of the Supreme Court in that famous case, most of you may be aware of it, Geeta Hariharan versus Reserve Bank of India. Geeta Hariharan versus Reserve Bank of India, 1999, 2 SCC 228. 1999, 2 SCC 228. This decision in turn makes a reference to a decision of two judges in Jijabai Vittalrao Dajre. Jijabai Vittalrao Dajre versus Pathan Khan and others. Jijabai Vittalrao Dajre versus Pathan Khan and others, 1970, 2 SCC 717. 1970, 2 SCC 717. See, that was a case where the property belonged to one X. It is his wife. The property belonged to a minor boy. The mother let out the property as though she was the guardian. In a suit for recovery of rent and eviction, the tenant contended, no, the father could be the guardian, mother could not be the guardian. Some such contentions were taken. The Supreme Court in that case took this view. We are not impressed with this contention of Mr. So-and-so. He referred us to certain decisions where the powers of a guardian of a minor have been considered, para 11 of this decision. But in the view that we take that the contention of Mr. So-and-so in this regard is not acceptable to us, no useful purpose will be served by reference to those decisions. We have already referred to the fact that the father and the mother of the appellant had fallen out and that the mother was living separately for over 20 years. There is a dispute between the couple. For 20 years, they were separate. It was the mother who was actually managing the affairs of her minor daughter, who was under care and protection. From 1951 onwards, the mother, in the usual course of management, had been leasing out the properties of the appellant to the tenant. Though from 1950, etc., it is no doubt true that the father was alive, but he was not taking any interest in the affairs of the minor, and it was as good he was as if he was non-existent so far as the minor appellant was concerned. This is important for us. Father was alive, but he was not taking any interest in the affairs of the minor, and it was as good as if it was non-existent so far as the minor appellant was concerned. We are inclined to agree with the view of the High Court that in the particular circumstances of this case, the mother can be considered to be the natural guardian of her minor daughter. It is needless to state that even before the passing of the Hindu Minority and Guardianship Act, the mother is the natural guardian after the father. The above act came into force on such and such a day. Now, in this Geeta Hariharan case, there was one other matter. It was Dr. Vandana Shiva versus Jayanta. It is sufficient for us if we just know the facts relating to this Geeta Hariharan's case. So this Geeta Hariharan and her husband, they had some matrimonial issues. They were separate. Now, Geeta Hariharan wanted to open an account in the name of her minor child. The bank raised an objection saying when the father of the minor was alive, as per RBI circulars and guidelines, the mother could not act as natural guardian and could not act as guardian and sign the application for the opening of the account. Ultimately, the matter reached the Supreme Court. As I already told you, some passages from this Jijabhai were referred to by the Supreme Court. What is this after? Normally, it means after the death of the father. The Supreme Court has said the word after will have to be interpreted as in the absence of. I am reading para 10 of the judgment. We are of the view. Before that, let me also read para 8. Is that the correct way of understanding the section? And does the word after the section mean only after the lifetime? Only after the lifetime of the father, only after his death? If this question is answered in the affirmative, the section has to be struck out as unconstitutional. In fact, the constitutional validity of this section was under challenge in this. So that is the meaning to be given. Then the provision itself has to be struck out as unconstitutional, as it undoubtedly violates gender equality, one of the basic principles of our Constitution. The Hindu Minority and Guardianship Act came into force in 1956, that is 6 years after the Constitution. Did Parliament intend to transgress the constitutional limits or ignore the fundamental rights guaranteed by the Constitution, which essentially prohibits discrimination on the grounds of sex? In our opinion, no. It is well settled that if for one construction, no need, then para 10. We are of the view that section 6A is capable of such construction as would retain it within the constitutional limits. What the Supreme Court has said is, there is a presumption that a provision is constitutionally valid. A statute is constitutionally valid. A strong case will have to be made out for declaring the statute as constitutionally, or declaring the statute or any provision of a statute as ultra vires the Constitution. So we will have to harmonize the various provisions and, as far as possible, uphold its constitutional validity. That has been the consistent view of the Supreme Court. So what the Supreme Court says is, well, if the literal interpretation is given, then we will have to strike down that section as unconstitutional. We are of the view that Section 6A is capable of such construction as would retain it within the constitutional limits. There is no need to strike it down. It's only a question of interpretation. The word after need not necessarily mean after the lifetime. In the context in which it appears in Section 6A, it means in the absence of. The word absence therein, referring to the father's absence from the care of the minor's property or person, or for any reason whatever. If the father is wholly indifferent to the matters of the minor, even if he is living with the mother, that's important, or he is by virtue of mutual understanding between the father and the mother, the latter is put exclusively in charge of the minor, or the father is physically unable to take care of the minor, either because of his staying away from the place where the mother and the minor are living, or because of his physical or mental incapacity. In all such like situations, the father can be considered to be absent, and the mother, being a recognized natural guardian, can act validly on behalf of the minor as the guardian. Such an interpretation will be the natural outcome of a harmonious construction of sections 4 and 6 without causing any violence to the language of section. Thereafter, the Supreme Court has referred to the Bichar line. Now, one thing should be made clear. It is not as if there should be some matrimonial dispute between the father and the mother, and the child is with the mother. It's only in such cases the mother can act as the natural guardian, even though the father is not it. As the Supreme Court itself has put it, if he is mentally incapable of acting, physically unable to do, or staying away for a firm reason, the husband is in a foreign country, he can't come here, child has to be admitted to the school in the month of June. The mother cannot wait for the father to come and sign the application form. Immediately an account needs to be opened. For all these purposes, the Supreme Court has placed this interpretation. Even in a case where the relationship between the couple is quite cordial, still there may be situations where the mother has to act as natural guardian. The rest of it you can read for yourself. So this is the interpretation that is placed. Therefore, even when the father is alive, the mother can act as natural guardian. The rider being father is indifferent to the affairs of the child, or the parents have, couple have fallen apart, or the father for some reason is not staying with the child. It is the mother who is taking care of the child in all these situations. Now, this is with regard to the interpretation placed by the Supreme Court about the word after. So we have understood who a natural guardian is. Then we will go to the powers of a natural guardian. This is yet another important section where there is a lot of confusion. Section 8. Powers of natural guardian. The natural guardian of a Hindu minor has power, subject to the provisions of this section, to do all acts which are necessary or reasonable and proper for the benefit of the minor, or for the realization, protection, or benefit of the minor's estate, but the guardian can in no case bind the minor by a personal covenant. Any act which the guardian does should be for the benefit of the minor child, but no liability can cast on the child because of some contract or covenant entered into by the natural guardian. Now, this subsection 1 refers to certain powers of the natural guardian for realization, protection, or benefit of the minor's estate. What is this minor's estate? Well, some grandfather or grandmother might have gifted a property to the minor. Somebody would have left behind a will. The testator dies. The minor child becomes the owner of the property at the death of the testator. It is not that the child itself should earn something, no. a property gifted to the minor, a property bequeathed to the minor, which becomes the minor's property after the death of the testator. So these are properties which are the properties of the minor. They are not properties in which they are not co-partnership property or joint family property in which the minor has an interest. More about it a little later. Section 8 refers to a property which exclusively belongs to the minor. Let there be no confusion about it. I am giving a decision of the Supreme Court also on this point. So it is to deal with that property, not necessarily property, to do every act which is beneficial to the minor. The natural guardian has that power. The subsection 1 starts with subject to the provisions of this section. What are those restrictions? Let us go to subsection 2. The natural guardian shall not, without the previous permission of the court, mortgage or charge or transfer by sale, gift, exchange or otherwise, any part of the immovable property of the minor. Mark those words. Any part of the immovable property of the minor. What is it this section prohibits? It prohibits the transfer of the immovable property of a minor by a natural guardian without the permission of the court. No permission is required for transfer of minor's undivided interest to the co-partner. It is covered by a decision of the Supreme Court. There are a good number of judgments of the Karnataka High Court. Since the audience is not confined to Karnataka, I am not referring to it, but Supreme Court has said this. So for minor's interest in the co-partner, no permission is required under Section 8. It is extremely important. In suits for partition, what happens is some vague notions. The minor has not challenged the alienation within 3 years after attaining majority. Some such vague notions are there. I am also referring to the provisions of the Limitation Act in this regard. No. Then 2B, lease any part of such property for a term exceeding 5 years or for a term extending more than 1 year beyond the date on which the minor will attain majority. Then what is the effect of such an alienation or mortgage, charge, letting out without obtaining the previous permission of the court? That is contained in subsection 3. Any disposal of immovable property by a natural guardian in contravention of subsection 1 or subsection 2 is voidable at the instance of the minor or any person claiming under him. I want lawyers to be very, very careful in this regard. Having worked in the trial court for quite some time, I find in many cases, without looking to the provisions, mechanically an averment is made in the pleadings. The transfer is void, null and void, non-est, illegal. No, it's a voidable thing. See, let me slightly deviate. Under the Indian Contract Act, all those vitiating factors do not render the contract void. Undue influence, coercion, fraud, misrepresentation, they all render the contract voidable. Kindly refer to section 19 and 19A of the Indian Contract Act. A contract by mutual mistake, section 20, that renders the contract, I believe, a void contract. And 23 gives a list of circumstances which renders the contract unlawful and void. So therefore, when we draft a plaint or written statement, or when we advise our clients, or when we make submissions in the court, let us be very clear about the substantive law. Procedure, of course, it takes care. You need not worry so much about it. But because we will have to properly enlighten the court about the correct legal position. So we should be very clear. Let us not just make some passing remarks without correctly understanding the concepts. Let us not say it's a void transaction and all that. No. It is a voidable transaction. And then voidable at whose option? Voidable at the option of the minor. It is voidable at the instance of the minor or any person claiming under him. No court shall grant permission to the natural guardian to do any of the acts mentioned in subsection 2, except in the case of necessity or for an evident advantage to the minor. Minor has some serious ailments, health issues, substantial sum of money is required. Natural guardian is unable to raise money. Minor's property necessarily needs to be mortgaged, alienated, let out. For those purposes, court's permission is required. Court should be satisfied about that need. The Guardian and Wards Act shall apply to, and in respect of any application or for obtaining the permission of the court under subsection 2, in all respects, as if it were an application for obtaining the permission of the court under section 29 of that act. That's why I just thought of including section 29 also here. But then later I thought, let me have a separate session on the Guardian and Wards Act. So the application would be under section 29 of the Act, maybe by way of abundant caution, you can say read with section 8. Procedure that is contemplated is under section 29 of the Guardian and Wards Act. A detailed procedure is given as to what is required to be done. And in particular, proceedings in connection with the application shall be deemed to be proceedings under that Act. So even if an application is filed under section 8, that would be deemed to be a proceeding under section 29 of the Guardian and Wards Act. The court shall observe the procedure and have the power specified in subsections 2, 3, and 4 of section 31 of that Act. And an appeal shall lie from an order of the court refusing permission to the natural guardian to do any of the acts mentioned in subsection 2 of this section to the court to which appeals ordinarily lie from the decisions of that court. Well, you know the hierarchy, it lies to that court. What is that court? In this section, court means the city civil court or a district court or a court empowered under section 4A of the Guardian and Wards Act within the local limits of whose jurisdiction the immovable property in respect of which the application is made is situate, and where the immovable property is situate within the jurisdiction of more than one such court, means the court within the local limits of whose jurisdiction any portion of the property is situate. So the court which has jurisdiction under the Guardian and Wards Act is not our usual court, civil judge, senior civil judge. Court is defined there. Of course, either the, at least in the state of Karnataka, is the district judge, or if the powers are delegated to the senior civil judge under that act. So now, section 8 is important for us. It refers to the separate property of a minor. Well, where is the question of the minor acquiring a property? Obviously, he may not be financially sound to acquire a property. Somebody might have gifted, somebody might have bequeathed, or somebody might have given him some gift on birthday and other things. A good sum is available at his credit. Property might have been purchased for his benefit. He becomes the owner. For letting out that property, for sale of that property, for mortgage of that property, permission of the court is required. That court is the court referred to in the Guardian and Wards Act. Application has to be filed under section 29 of the Guardian and Wards Act. Detailed procedure is contemplated under 29 and 31 of that Act. That has to be followed. Where do we get this? Now, I said repeatedly that the property referred to in section 8 is the minor's property and not his interest in the undivided interest in the co-partnership. Let us go back to section 6. Natural guardians of a Hindu minor. The natural guardians of a Hindu minor, in respect of the minor's person, as well as in respect of the minor's property, excluding his or her undivided interest in the joint family property. Here you have one indication that minor's undivided interest in the joint family property is not covered here. Then please go to section 12 of the Act. Where a minor has an undivided interest in joint family property and the property is under the management of an adult member of the family, no guardian shall be appointed for the minor in respect of such undivided interest. So no question of appointing a guardian under the Guardian and Wards Act for the minor's undivided interest in the property, provided that nothing in this section shall be deemed to affect the jurisdiction of a High Court to appoint a guardian in respect of such interest. High Court has been given some extraordinary powers in this regard. Let us not worry about it. So in the normal course, in respect to the minor's undivided interest in the joint family property, there is no question of appointing a guardian. Now, from a combined reading of section 6, 8, and 12 of the enactment, as I said, the Karnataka High Court in a series of judgments has taken such a view. The Supreme Court has also taken a view that the question of any person seeking permission of the court to alienate minors' interest in the joint family property does not arise. You may refer to 1996 8 SCC 54. 1996 8 SCC 54. Sri Narayan Bal versus Sridhar Sutar. Sri Narayan Bal versus Sridhar Sutar. 1996 8 SCC 54. I am reading para 5 of the judgment of the Supreme Court. Before that, in para 4, the Supreme Court refers to section 6 and 12 of the Act. Then para 5 gives the ratio. With regard to the undivided interest of the Hindu minor in a joint family property, the provisions aforesaid, which are those provisions aforesaid, 6 and 12, are beads of the same string. See how beautifully the Supreme Court has put. Are beads of the same string and need to be viewed in a single glimpse simultaneously in conjunction with each other. Each provision, and in particular section 8, cannot be viewed in isolation. If read together, which are those sections which need to be read together? Sections 4, section 6, 8, and 12. If read together, the intent of the legislation in this beneficial legislation becomes manifest. Ordinarily, the law does not envisage a natural guardian of the undivided interest of a Hindu minor in joint family property. Why? It is the manager or karta of the joint family who takes care of not only the minor's interest, but his own interest and the interest of everybody concerned. The natural guardian of the property of a Hindu minor, the natural guardian of the property of a Hindu minor, other than the undivided interest in the joint family property, is alone contemplated under section 8, whereunder his powers and duties are defined. Section 12 calls out an exception to the rule that should there be no adult member of the joint family in management of the joint family property, in which the minor has an undivided interest, a guardian may be appointed, but ordinarily no guardian shall be appointed for such undivided interest. The adult member of the family in the management of the joint family property may be a male or a female, not necessarily the karta. The power of the High Court otherwise to appoint a guardian in situations justifying has been preserved. This is the legislative scheme on the subject. Under section 8, a natural guardian of the property of the Hindu minor, before he disposes of any immovable property of the minor, not his interest in the co-partnership property, must seek permission of the court. But since there need be no natural guardian for the minor's undivided interest in the joint family property, as provided under section 6 and 12, the previous permission of the court under section 8 for disposing of the undivided interest of the minor in the joint family property is not required. The joint family by itself is a legal entity capable of acting through its karta and other adult male members of the family, in the management of the joint Hindu family property. Thus, Section 8, in the express terms of Section 6 and 12, would not be applicable where a joint Hindu family property is sold or disposed of by the Karta, involving an undivided interest to the minor in the said joint family property. This is important because oftentimes contentions are urged. Minor had an interest in the joint family property. Without taking the permission of the court, his interest has also been sold. First of all, no permission is required. Secondly, as I said, the alienation is void. It is not at all void. Then, even if it is minor's property, the alienation is not void, it is voidable. Let us be very clear about this. We may, in this regard, refer to a passage from Mullah's Hindu law. Chapter 12 in Mullah's Hindu law deals with this co-parsonery and co-parsonery property. There is reference to this alienation of co-parsonery property, alienation of undivided co-parsonery interest, setting aside alienation and other things. Alienation of co-parsonery property. In Mullah's Hindu law, some people say it as section, some people say it as synopsis, note, or para number, whatever it is. 255. Who may alienate co-parsonery property? The following persons alone have the power to alienate co-parsonery property so as to pass a good title to the alienee. Who are they? The whole body of co-parsoners where they are all adults. The manager to the extent mentioned in section 242. The father to the extent mentioned in section 256. A sole surviving co-partner in the circumstances mentioned in 257. So, manager to the extent mentioned in section 242. Let us go to 242. Alienation by the manager of co-parsonery property for legal necessity. All of you are aware of this. The power of the manager of a joint Hindu family to alienate joint family property is analogous to that of a manager for an infant heir as defined by the Judicial Committee in that famous Hanuman Prasad versus Musmal Bhuji. Next, the manager of a joint Hindu family has power to alienate for value, that is for consideration, joint family property so as to bind the interests of both adult and minor co-parsoners. That is why I am repeatedly telling permission under section 8 is not required for alienation of minors' interest in the co-parsonary. It is only for the minor's exclusive property. Such permission is required, and if without permission, if the alienation is made, it is not void, but it is only voidable at the instance of the minor, for which there is a period of limitation. So, if it is minor's interest in the co-parsonary, there is no question of seeking it is set aside. It is not at all void. It is not voidable. The only thing is the purchaser has to establish that the manager sold it for legal necessity or benefit of estate. Law is well settled. The burden is on the alienee to show that there existed that legal necessity. Just as the manager can dispose of the interest of an adult co-partner also for the benefit of the family and legal necessity, he can as well dispose of the minor's interest also. Then, alienation by the father. That is section 256. A Hindu father as such has special powers alienating the co-partner property, which no other co-partner has. So, father has that special power. And in fact, in this book itself, it is stated, usually the father will also be the manager. So, practically, the powers of the father and manager almost would be the same. What are those powers of a Hindu father. He may make a gift of the ancestral mobile property to the extent mentioned in 225 and even of ancestral immobile property to the extent mentioned in 226. He may sell or mortgage ancestral property, whether mobile or immobile, including the interest of his sons, grandsons, and great grandsons therein, for payment of his own debt, provided the debt was an antecedent debt and was not incurred for immoral or illegal purposes. It should not be tainted with illegality or immorality. It should be antecedent in point of time and point of fact. You know all that. The father in all cases, naturally, and in the case of minor sons, necessarily, the manager of the joint family. As manager, he has the power to alienate proportionary property, but only in the cases specified in 242, that is for legalness. As father, he has power to alienate the proportionary property, beyond it, he has no power. Now, what is this period of limitation? As I said, we have some notion. It is a joint family property. Minor had an interest. First submission, permission was required. So I have told you permission is not required. Second contention, sale is void. It is not void. It is only voidable, that too minus property. Voidable at the instance of the minor. When is that suit to be brought? Let us have a clear picture about it. Let us go to Article 60 of the Limitation Act. One thing I want to make it clear, because I don't think that I had an occasion to refer to this on this platform at any time. I have heard submissions being made when it is a question of limitation. Limitation has started from the date of cause of action. I don't find any article in the Limitation Act anywhere saying that limitation for any suit starts from the date of cause of action. The second submission is the suit is filed when the plaintiff came to know about a particular thing, or the application was filed when he had knowledge. There are only some 5 or 6 articles in the Limitation Act. You may carefully make a list of that, which would give you an indication that limitation starts from the date of knowledge. Otherwise, no. I jocularly tell, if you make a submission that limitation starts from the date of knowledge, that would be our limited knowledge of the law of limitation. So as lawyers and judicial officers, let us refer to the statute and see. In these money suits, there are a number of provisions relating to recovery of money. We usually say 3 years. 3 years from which date? Which is that article? I have found in most of the cases, it is the restitutory article 113 that applies. None of the specified articles would apply for recovery of money, except some promissory note and other things. So let us not make a mistake hereafter of saying that the limitations started from the date of cause of action, from the date on which the plaintiff became aware, or from the date on which the applicant became aware of it. Maybe when it comes to a question of condonation of delay or setting aside the abatement, date of knowledge becomes material, but limitation does not start from the date of knowledge. Let us be clear about it. Now, Article 60. To set aside a transfer of property made by the guardian of a ward, that is minor, by the ward, that is by the minor, who has attained majority, 3 years from the time when the ward attains majority. I am under an impression that taking a cue from this, many are under the impression that even if it is an alienation of the minor's interest in the proportionary property, he should have challenged it within 3 years. No. It is in respect of the minor's own property. If an alienation is made without the permission of the court by the guardian, then limitation starts when the ward attains majority. So he has to file the suit within 3 years from the date on which he attains majority. So Article 60, I say with all emphasis, my command, that it applies to the property of a minor, not his interest in the co-partnership property. Now, let me take you to Article 109. Suit by a Hindu governed by Mitachara law to set aside his father's alienation of ancestral property. As I said, in fact, there is no specific section which provides for a limitation for setting aside an alienation by the manager. Probably we may bring that also under Article 109. To set aside his father's alienation of ancestral property, not 3 years. It is 12 years from which date? Not from the date of that assumed knowledge. When the alienee takes possession of the property. Not from the date of sale, not from the date when we came to know certain things. No. It is 12 years from the time when the alienee takes possession of the property. So it is Article 60 that applies to setting aside an alienation made by a guardian without the permission of the court by the minor, which alienation is optional and it is voidable at his option, and therefore suit has to be filed within 3 years. If it is of the ancestral property, 12 years from the time when. We may also refer to a commentary on the law of limitation and prescription by U.N. Mitra. It is in the Tagore Law Lecture series. This Tagore Law Lecture series, it is like a Mullah, a standard text. Here, at page 1269, some discussion starts here, 1269. It is in respect of Article 60. A condition precedent for the application of the article is that the property alienated should belong to the ward, that is the minor, and it must have passed out of the hands of the minor. So it is not his interest in the co-partnership property. Then page 1270. This article will have no application where the guardian had alienated the property as his own or has been the joint family property of himself and the minor. Likewise, a sale made by a person not as the guardian of the minor, but in his capacity as manager of the joint family will not be within this article. A sale of joint family property by the Karta and by the mother of the minor as his guardian would not be characterized as a sale by a guardian on behalf of the minor so as to attract this provision. Then at page 1287, of course, different editions would have different pages. The one I have is 14th edition. Justice S.S. Subramani has edited this book, former judge of the Madras High Court, volume 2. Alienation of joint family property, synopsis number 16. An undivided share in Hindu joint family property is not property which can be dealt with by a guardian. Where the manager of a Hindu joint family alienates the co-partnership property and a minor member seeks to avoid such alienation, the case does not fall within this article since the manager is not the guardian of the minor members. The article has no application where a guardian alienates property of himself and the minor. So therefore, these things are very clear. So let there be no confusion about these things. So first of all, Section 8 has no application to the alienation of a minor's interest in the co-partnership. It is in respect of his own property. Permission of the court is required. That application will have to be filed under Section 29 of the Guardian and Wards Act. Procedure contemplated under 29 and 31 will have to be followed, a detailed procedure. Court will have to satisfy itself that the alienation is for the benefit of the minor. Well, as I said, if I take a separate session on Guardian and Wards Act, I will deal with that in some great detail. Then, a limitation also I have told you. Powers of testamentary guardian. Let us go to section 9. Who is the testamentary guardian? As I said, the father or the mother by a will may say, well, after our death, so and so shall be the guardian of our minor child. What are his powers? Section 9. A Hindu father entitled to act as the natural guardian of his minor legitimate children may, by will, appoint a guardian for any of them in respect to the minor's person or in respect to the minor's property other than the undivided interest referred to in section 12. So you will find in section 6, 12, 9, everywhere it is stated, otherwise, other than the undivided interest. Or because why? It is the manager who takes care of it. Karta takes care of it. An appointment made under subsection 1 shall have no effect if the father predeceases the mother, but shall revive if the mother dies without appointing by will. A Hindu widow entitled to act as the natural guardian of her minor legitimate children, and a Hindu mother entitled to act as the natural guardian of her minor legitimate children by reason of the fact that the father has become disentitled to act as such, may by will appoint a guardian for initial, etc. Other details are given. Then we have this de facto guardian. In fact, this commentary on Hindu law tells de facto guardian, there's nothing like a de facto guardian. The person acts as though he's a guardian. In fact, the Guardian and Watts Act provides for it in the sense a person acts as though he is a guardian, therefore he can be appointed as a guardian. De facto guardian not to deal with minor's property. After the commencement of this act, no person shall be entitled to dispose of or deal with the property of a Hindu minor merely on the ground of his or her being the de facto guardian, because it is only the natural guardian who can do it, that too with the permission of the court, as contemplated under section 8, procedure provided by the Guardian and Wards Act. Then section 13, this I want to make it clear. In the appointment or declaration of any person as guardian of a Hindu minor by a court, the welfare of the minor shall be the paramount consideration. No person shall be entitled to the guardianship by virtue of the provisions of this act or of any law related to guardianship in marriage among Hindus, if the court is of opinion that his or her guardianship will not be for the welfare of the minor. I started telling that the Hindu Minority and Guardianship Act is a piece of substantive law, whereas Guardian and Wards Act is a procedural enactment. Now, this appointment or declaration of person as a guardian or child's custody, they are all matters covered by the Guardian and Wards Act. So when the court deals with such applications under the Guardian and Wards Act, section 13 of the Hindu Minority and Guardianship Act, which is a piece of substantive law, also needs to be kept in view. I make it clear, Hindu Minority and Guardianship Act by itself does not provide for any application for making custody. It is covered by the Guardian and Wards Act. Here, appointment or declaration of a person as a guardian or giving a person child to the custody of so and so, all those things are covered by the Guardian and Wards Act. What section 13 of this act says is, while making such appointment, while making such declaration, while giving custody, the consideration should be, the paramount consideration should be the welfare of the minor. So therefore, there is no question of making any application under section 13 of the Hindu Minority and Guardianship Act, either for appointment of a person as a guardian or for declaration or for custody. All that is governed by the provisions of the Guardian and Wards Act. As I said, the subject is itself minority and guardianship, a minor subject. Quite unusually, I have finished it within 12 hours, 15 minutes. We will have a separate session on some other occasion for Guardian and Wards Act. So I leave with a hope that hereafter no submissions should be made, no submissions should be entertained by the courts when it is contended that the alienation is without the permission of the court. The alienation of even a joint family interest would have to be challenged within 3 years and all that. Let us have a clear idea of the substantive law. Let us refresh our memories whenever we draft pleadings or write judgments or when we make submissions. Let us not just presume certain things and go ahead. Yes, any questions?
No, sir. It can be only one who just wants to have a snippet. If you want to give a bird eye view, how will you sum it up all in 5 to 10 minutes? So that people,
Bird's eye view of what?
the entire session in 5 minutes. Qua limitation, qua alienation.
Yes, I have told this act is a substantive law. It is exclusive to Hindus, whereas Guardian and Watts Act, it is religion neutral. It applies to persons of all religions. Then natural guardians, father, after him, afterward, the Supreme Court has interpreted in the absence of, not necessarily after his death, the mother. Custody of the child below 5 years shall ordinarily be with the mother. Then powers of natural guardian, I have exhausted myself by repeatedly telling it as a guardian of some junior lawyers here. Then I have referred to certain passages. I think barring this.
Limitation part.
Yes.
Limitation.
A limitation I have said, if it is Article 60 refers to the alienation of minor separate property, that if it is, they have to be filed within, as far as Article 109, if the father alienates the joint family property, then they have to be filed within 12 years from the time when the alienee takes possession.
Thank you, sir, for sharing your knowledge. And we will definitely do the part next time. Everyone stay safe.
Nice.
Stay safe and blessed. And thank you again, Mr. Kaushik and his wife, for sparing the time for the people at large. Thank you.
You must also thank me for completing within 1 hour.
No. That's always in the
normally it used to go for 2 hours.
It's not the time passage, but because we know that it will always be exhaustive and understandable. Thank you.